Well, good afternoon, everyone. It is 3:01 Eastern Time. We're going to go ahead and get started with the HEARTH Act training for tribes and lenders. This is Iris Friday. I'm with HUD's Office of Native American Programs, and I just want to thank our partners at the Bureau of Indian Affairs for their partnership in hosting today's session with us. And just want to say we appreciate the opportunity to work together with you all. I am going to go ahead and turn this over to Carla Clark, who's going to get us started with today's training. And again, welcome and thank you for being here.
Great, thank you, Iris. Good afternoon, everyone, and welcome to the overview session on helping expedite and advance Responsible Tribal Home Ownership Act of 2012, also known as the HEARTH Act. We look forward to a great session today, and we appreciate your participation. My name is Carla Clark. I'm the Division Chief for the Division of Real Estate Services out of BIA Central Office. BIA has been busily working to support and implement various departmental priorities and initiatives, which includes HEARTH. To meet the scope of our challenges and the multiple overlapping priorities, the mission of our offices within trust services are to protect, develop, manage, and enhance trust resources for the benefit of American Indian and Alaska Native peoples and expand economic opportunities through effective trust management that recognizes the support tribes' self-governance and self-determination needs. We are also committed to fostering partnerships and improving communications with our federal partners and stakeholders. Under the HEARTH Act, once a tribe's governing tribal leasing regulations are submitted to and approved by the Secretary of the Interior, they are authorized to negotiate and enter into surface leases or under their approved HEARTH Act regulations without further approval from the Department of Interior. Our session is presented by BIA Office of Trust Services, Division of Real Estate Services, Sharon Kidman, Senior Realty Specialist, and our National HEARTH Act Coordinator, in collaboration with Indian Affairs Office of the Solicitor, Suzanne Nunn, and David Moran, both Senior Attorney Advisors. On today's session, we will not present or discuss our TAMS system. Since HEARTH has been implemented, there have been over 100 tribal leasing regulations approved. Currently, we are at a total of 112 tribal leasing regulations approved for 91 tribes. Of those approved regulations, there are several tribes who have multiple approved leasing regulations. However, we only count them once. In the upcoming fiscal year, we hope to have the same success with tribes and approved HEARTH Act regulations. I appreciate your time today, and I am now going to turn our training over to Ms. Sharon Kidman. Thank you.
Good afternoon, everyone. Thank you for joining us. As Carla said, my name is Sharon Kidman. I am a senior realty specialist here at the Division of Real Estate Services. If you hear me say DRES, that is the short term for that long name. So as I go throughout, I will be saying DRES here and there so that you will know what it is. I have been with the Bureau for 23 years of federal service, all of it in trust services. So I began my career in the Land Titles and Records Office within the Southwest region, where we serviced 3 regions, Western, Navajo, and Southwest. I promoted, after being there for 7 years, I promoted to real estate services, where I was a realty specialist and did work at the local agency, as well as did details with the region to help the region out. And then I, 5 years ago, almost 5 years, promoted to this position at Central Office. And I'm excited. This position is a wonderful chance to help the tribes with more of their sovereignty and to be able to help them along the way with their HEARTH Act leasing regulations. So I know that we've got a variation of a crowd today. We have some HUD folks in here, other lenders, and we also have tribal folks with us today. So we say welcome to all of you. Hopefully everybody can see the presentation. Today, we will be going over the internal review process. There will be a short part where I will turn it over to the Office of the Solicitor to David and Suzanne, where they will give just a short, brief overview of what they do during their review part. But other than that, we will be sticking to the PowerPoint as we go along. Getting started. The Bureau has provided a mechanism for federally recognized tribes to approve, manage, and enforce leases of their tribal trust and restricted lands for business, residential, agricultural, wind, and solar purposes without a lease review by the Bureau of Indian Affairs or lease approval by the Secretary of the Interior. And this is all providing that the tribe's leasing regulations have been approved by the BIA, and the tribe's leasing regulations were approved by the Secretary and the Interior prior to execution of the lease itself. I'm going to go ahead and enlarge this a little bit more so that you guys can see the little notes at the bottom. On this one, it says note leases and their related amendments, assignments, etc. that have been approved under 25 CFR Part 162 will continue to be subject to Part 162 and are not governed by a tribe's leasing regulations under the HEARTH Act. So as we go along, it's a very important note for not only the tribes, but lenders to understand that once these regulations are approved and they are in effect, that current existing 162 leases done prior to that approval of their HEARTH Act, of the tribe's HEARTH Act, those leases will remain as 162 leases, and they will be governed by 162. The next slide. Tribal leasing regulations must meet minimum requirements to be eligible for secretarial approval. The first bullet talks about consistency with BIA's leasing regulations at 25 CFR Part 162. And just as an FYI for the tribes listening, this is not a meet and exceed standard. The tribes are welcome to create their own. There are many on the website, and if you look in the chat, I did place in the chat the website links for you to click on and to save on your own desktop if you so wish to. And then you can browse the page at your own convenience. The second bullet point talks about providing for an environmental review process that includes 1, identification and evaluation of the significant effects of the proposed lease on the environment. The tribe must define the terms environment, significant effects, and public. Number 2, a period for public notice and comment related to any significant impacts of the proposed lease or lease activity on the environment. Number 3, the tribe's response to relevant and substantive public comments on environmental impacts prior to tribal approval of the lease. And continuing on, the minimum requirements for tribal leasing regulations are that they may only authorize the following lease types and maximum terms. So at the very top, we have business, agricultural, and wind and solar leases. These are 25 years, but may include an option to renew for up to 2 additional terms at no more than 25 years each. That's a total maximum term of 75 years under the HEARTH Act. There's also the wind energy evaluation leases, also known as wheels. Those are 3-year term and 1 option to renew for 3 years. And those may convert to WSR leases at the end of the initial 3-year term if expressly stated in the lease. The last bullet point there says residential, public, religious, educational, or recreational leases are for a term of 75 years, a single term, and it can be less than that. And then there is a note on this one as well. Other lease terms that have been recognized for a tribe under 25 USC 415 are not applicable in conjunction with tribal leasing regulations issued under the HEARTH Act. Also, the minimum requirements also apply only to tribal trust and restricted land, not to lands held in trust for individual Indian landowners, fee lands, or fractionated interests. Also, they must address tribal authority to approve leasehold mortgages, but not mortgages of tribal land. The last bullet says, must not authorize exploration, development, or extraction of any mineral resources. The next page, these are the factors to consider for a tribe when they are going through the leasing process for HEARTH Act. They're drafting their leasing code. One is the funding. It's added costs or the diminishment of existing funds associated with undertaking full administration and management of leasing itself. So I imagine the tribes prior to HEARTH activities are looking into the 638, the compact contract options, so that they can fully take on their HEARTH duties. The next one, and we talked about the environmental review process. Tribes may request and the secretary may provide technical support for development of an environmental review process. However, there is no requirement for the BIA to perform environmental reviews after approval of leasing regulations. Existing and future leases. Leases already in place, executed and approved under 25 CFR 162 are still subject to BIA's leasing regulations. Approval of HEARTH Act regulations does not preclude tribes from electing secretarial approval process under 25 CFR 162. What does that mean? That actually means that the tribe has the best of both worlds. They have the HEARTH Act authority, and they also still have access to 25 CFR Part 162. And the last, second to the last bullet, lease enforcement, violations, cancellations. Upon reasonable notice from the tribe, the secretary may enforce provisions of or cancel a lease. However, it is anticipated that tribes will manage all aspects of those leases approved under their tribal HEARTH Act regulations. Assertions of a tribe's noncompliance with its own regulations. After exhausting tribal remedies, an interested party may petition the secretary to review a tribe's compliance with its own regulations. And folks, as Carla said, if you have any questions, please put them in the chat and we will get to them at the end of the presentation. Moving on to the next slide. Initially, when the process begins, it is the tribe who begins it. The tribe will be drafting their own regulations. They will approve it. They will authorize it with their tribal resolution, and they will send that package in. This is the steps that they take to go through it. So there's 3 basic steps for review and approval. The first one is initial submission. The tribe drafts, approves, and submits leasing regulations to BIA's central office. The review includes any modifications and resubmissions, and then the final approval by the Secretary of the Interior. On this slide, we put in here in depth what is needed for the initial submission. So to any of the tribes that are listening, the initial submission must include an original cover letter that includes 1, a request for review and approval of the regulations under the HEARTH Act, 2, contact information for parties with decision-making authority regarding the regulations, for example, the tribal officers, legal counsel, and 3, any special circumstances regarding submission of the regulations, like an urgent need for approval, a unique provision included in the regulations, etc. So that's what should be included in the cover letter. The package should also include one original of the regulations approved by the tribe and signed by the authorized tribal parties, and a tribal resolution authorizing the regulation that must be an original and not a copy. If the tribe submits a copy or the submission is incomplete, it will be considered as unofficial and will not be reviewed or forwarded for decision until an original fully executed regulation and tribal resolution is received. And then the mailing address is listed below for the tribes who are on the call today. You may put that to the attention of Miss Carla Clark. She is the Chief Division of Real Estate Services, and the address is listed there. For everyone's FYI, this PowerPoint is currently on the website, but we will replace the one on the website with this one today because we did just one or two small tweaks to this one. So you will all receive this PowerPoint today, but in future it will also be listed on the website. And I will show you where to go to get a copy of it. On the next slide, step 2, it's the BIA review, which includes the regional office, the Division of Real Estate Services, that is our level central office DRES, and the office of the solicitor. And at this point, I'm going to go ahead and turn the presentation over to Ms. Suzanne Nunn and Mr. David Moran of the Office of the Solicitor.
Thanks, Sharon. Hi, everybody. This is Suzanne. I've been with the Office of Solicitor for 5 years. And before that, came from the National Indian Gaming Commission. Prior to that, I have about 10 years experience in tribal governments, doing leasing and lending. So David, would you like to go ahead and introduce yourself?
Sure thing. This is David Moran. I've been with the solicitor since 1991. Prior to that, I was a legislative assistant, working on the U.S. Senate for Senator from New Mexico. After that, basically, I did a stint with the FCC, and then I was in private practice for about 4 years, in which I dealt with financial institutions, did a lot of commercial real estate, both transactional work and litigation. But have been with the solicitor since 91. Which I've done a variety of, worked on a variety of issues, primarily water and land claims, basically oil and gas, trespass cases, just quite a few issues dealing just with the Indian lands. And basically have been, along with Suzanne, have been primary solicitors that review the HEARTH Act ordinances submitted by tribes for secretarial approval under the Act. Okay, thank you, Suzanne.
Sure, great, thanks. Our part of this is going to be actually rather short. We're just going to kind of, what we do when we get Tribal HEARTH Act regulations is we do a legal sufficiency review. We have a checklist that we've created to help us with the legal sufficiency review, but our standard that we use is that the Tribal HEARTH Act regulations have to be consistent with the 162 leasing regulations, the 25 CFR 162 leasing regulations. As Sharon had stated earlier, it's not a meets or exceeds standards, it's just a consistent with standard. When we do our legal sufficiency review, we look for specific things. There are mandatory provisions that must be in every Tribal HEARTH Act code, and there are some that we strongly suggest or recommend depending on the code. When we review each code, we keep in mind that every community is different. Every community has their own little areas of uniqueness, I guess, and they all operate differently from one another. There's very few tribes, people don't realize that a lot of tribes are, don't really operate the same across the board. So it's not a one size fits all kind of a legal sufficiency review. We rely on the region and the agency to give us the boots on the ground local knowledge of the tribe. And so when we do our legal sufficiency review and we have our discussions with DRES, we do look for assistance from the agency and the region. And when we do our legal sufficiency review, one of the things that we look for are leasehold regulations to show how the tribe handles any kind of a leasehold mortgage, which is, specific to you guys. When you're dealing with tribes on lending in Indian country, and if they want to use their HEARTH Act to execute a lease, you need to look at their HEARTH Act code and make sure that that the provisions, the leasehold mortgage provisions, are in that code and are applicable, and you have to make sure that they're followed. Some tribal regulations will say that the tribal council approves leasehold mortgages. Some say that leasehold mortgages don't need to be approved by the tribe. So you need to know what the tribe's HEARTH Act regulations are when you're dealing with those tribes. And we'd like to really point out that, as Sharon had stated earlier, it's really important to understand that tribes that 162 leases cannot in no way be converted to a HEARTH Act lease, and vice versa. So if there is a 162 lease and the tribe would like to use their HEARTH Act authority for that lease, they have to mutually terminate the lease. All the parties need to mutually terminate, or the lease needs to expire, and then an entire new lease has to be drawn up under the HEARTH Act regulation. The reason for this is that the 162 language is all secretarial authority, and the HEARTH Act language is the tribal authority. And because of those two different authorities, you cannot convert one lease to the other. And that's an important thing to understand. And I think that's really all we have. We are working with HUD to create language for loans under the HEARTH Act. We don't have language right now, but we are working on it. So David, would you like to add anything?
No, with regard to the language, again, I think what it is it's more technical language than anything else. I think basically indicating again, as the audience is probably aware, I think we have form leases that have language in it regarding that lending for under the various acts, HUD and others, veteran affairs, things of that nature, or basically that's recognized by 162, things of that nature. So it's just a matter of changing that can language over there to include language that the leases under the HEARTH Act have the same basically or legally binding as are the leases under secretarial approval under 162. So again, I don't I think we have had basically in the past lenders were always a little concerned that they're not sure whether they should be lending money on for mortgages, for leasehold mortgages, for leases that were approved under the HEARTH Act. And I think we're here to tell you today that there's really no distinction or no difference between them. They're both, as I say, I think should be treated the same under the law. So that's about all, Suzanne. Thank you.
Okay, I think that's all we have. If there are any specific questions that you guys have for David or I'll put our emails in the chat. Please feel free to contact us. We're happy to chat with you guys. So thank you very much for coming to the training. And Sharon, I'm going to throw this back to you.
Thank you, David and Suzanne. I wanted to just kind of, before we move to step 3 here, which is the final approval, to let everybody know that you can put your questions in the chat because I see some have joined later. So if you have questions, you can put them in the chat and we will answer them at the end of the presentation. So we've gone through step 1 and step 2 of the review process. Step 3 is secretarial approval. It's the final review within the offices of the Assistant Secretary, Indian Affairs and Secretarial Approval. So if you notice, it says offices, so it's more than one office that will review this once it leaves our hands for the final part. This last slide is kind of what Suzanne just mentioned. I know most of the lenders here are curious as to what is BIA's role. What will it look like after tribal leasing regulations are approved? Well, the first bullet talks about the lease review itself. It says the BIA does not review leases executed under a tribe's HEARTH Act leasing regulations for compliance with 25 CFR 162. So there is no more in-depth BIA review. That's one of the things. Number 2, the approval. The Secretary does not approve lease documents executed under a tribe's HEARTH Act leasing regulations authority. Lease documents are approved by tribal authority and according to the tribe's regulations. Recording. Tribes are required to provide BIA with a copy of all lease documents, the lease, the amendment, the assignment, leasehold mortgage, renewals and subleases, etc. The BIA or tribe, if it has contracted or compacted the related leasing authority, is responsible for encoding lease documents. So this is that bullet right here for the lenders and tribes on this call is very important to remember because across the nation, there are many variations of what is going on when a tribe does go HEARTH Act. So there are a very few, I could probably count them on one hand, that's the tribe has taken the leasing authority and the tribe has taken the use of TAMs. They have instituted that. They've gone through all their steps to do that. We will not be covering those steps today. I'm just pointing out that when a lender or somebody out in the field is dealing with a tribe and the tribe has HEARTH Act, then the lender must work directly with the tribe. However, the tribe may have not taken TAMs, in which case the tribe will send this document to BIA, to the local agency or region, whichever one is servicing them, and they will encode it and forward it for recording. But the point of contact in that whole situation is still the tribe. So the tribe is the one who is still the main point of contact for all questions related to their HEARTH Act lease that's been encoded and recorded and registered on a title status report. So let me read that again. It says, in preparation for encoding, a cursory review should be done before entry into the TAM system. So the realty specialist out in the field that's doing this, the BIA realty specialist, they are not going into in-depth reviews, like we said, but in order to encode it, they do need those significant things. One of them being the fully executed lease. The other one is a legal description that they can encode into TAMs, and one that is sufficient for LTRO to record. And that is all that they are looking for, and they can encode it. LTRO, the second bullet point, is responsible for recording lease documents. The BIA or tribe, as described in the bullet of 4 mentioned, is responsible for submitting HEARTH Act leases to LTRO for recordation purposes after they've been entered into the TAMS system. And then lease enforcement, violations, cancellation. It says under the HEARTH Act, tribes will manage all aspects of those leases approved under their tribal regulations. Second bullet, upon reasonable notice from the tribe, the secretary may enforce provisions of or cancel a lease, but that's upon notice from the tribe. Back to the first bullet right there, the tribe is still responsible to manage all aspects of that lease. Third bullet, situations may arise that are outside of the approved regulations. For example, trespass resulting from an unapproved right-of-way that is still under BIE's jurisdiction to act. And then we just went over this on another slide, tribal compliance with regulations. After exhausting tribal remedies, an interested party who is not the BIA may petition the secretary to review a tribe's compliance with its own regulations. So that, in a nutshell, this slide right here is the role that BIA plays after HEARTH Act has been implemented by a tribe. Essentially, if, like I said, if the tribe has not taken TAMs and has not made the necessary steps to do that, then they will still send that document to BIA agency or region to get it recorded, encode it first and record it. But it's still the tribe that will also submit the request for a title status report. So it is, the whole thing here is so that the tribe is able to do that for themselves and process their leases in a quicker, timelier fashion. So that is the end of our presentation for this PowerPoint slide. We will take the question. There was a question I seen pop up, and then I do want to go to the website because I do want to show the group here a few things on the website, but let's go to the chat. And there is a question that says, can a tribe take TAMs after obtaining approval for hearth leasing or at any time in that process? When you say take TAMs, they can, they have to go through steps to get, just like we do when we work for the BIA, we have to, our backgrounds must be checked. So the tribe must take steps to do that. So they can certainly have TAMs located at their tribal location in their tribal office, wherever that may be, and they can have TAMs, but they must go through a separate approval process for that. That's totally unrelated to HEARTH Act.
And I just want to jump in and say that TAM's database is a very, has a lot of personal identifiable information in it and is very sensitive information. And so not just anybody can access TAMs and see information. We have to be very careful about who accesses it. And so everybody has to go through a background check and it has to be approved. They have to have security clearance of some sort to get into TAMs. It can be done on a limited basis, possibly, but you'd have to check with maybe Carla or the region or somebody to find out if you have a specific tribe that's interested in obtaining access to TAMs.
Yeah, this is David. I mean, again, TAMS access is usually basically obtained more likely than not to the 638 process. I think once a tribe has contracted basically to perform some of the governmental functions for realty services in this case, they will have, as Suzanne indicated, very limited access. That access is only for that particular tribe's information, things of that nature. As Suzanne indicated, I think TAMS not only basically contains information regarding, what you would, the information you would find in the county clerk's office, regarding, title work, and basically location, I think legal descriptions of that nature. But it contains very, very, very sensitive and proprietary information of the tribes and also of individuals, so forth. So reason that access is very limited. And when it is provided, when tribes do obtain it, it's usually is limited to 1 or 2 or 3 persons who have gone through a background check and things of that nature. So I hope that answers the question.
Thank you, David and Suzanne. We have one more question, and this question is, do you have any model HEARTH Act codes and languages? Where can we find the HUD HEARTH Act language we can include in our tribal resolutions for mortgage lending?
I'll go ahead and answer that. Because every tribal community is different. We do not have a model HEARTH Act code. As I stated earlier, there is no one size fits all. So there is no model HEARTH Act code. However, we encourage you to go on to the BIA website where the list of approved tribal HEARTH Act codes can be found, and feel free to look at any one of those codes for any kind of sample language or anything like that that you would like to see. And as far as the HUD language, it is not available yet because it's not, we haven't come to an agreement. It hasn't actually been hashed out yet. So at this current time, there is no HUD HEARTH Act language that we can give to you to use. So go ahead,
Yeah,
David.
this is David. Just to add a little bit to what Suzanne indicated, I think again, there are no, model acts, as she said. But when you do look at the website, I would basically focus on the ones that were more recently approved. I think,
Yeah.
and like with every new statute, new act, I think basically that we've gotten better at what we require in those acts. The tribe's gotten better, I think, in drafting those. And so I think I would take a look at the ones that are more recent, the last couple of years, I think, and those would include provisions that basically you'll find in most HEARTH Acts ordinances going forward. On the point on, Iris, I don't know whether you could provide, some of the CAN language that is used for 162 leases, leasehold mortgages. But I think from the HUD perspective, but as Suzanne indicated, we don't have that language drafted yet or approved yet for the HEARTH Act. So.
And I do believe Iris is still on the call. I'm just not sure if she can speak at the moment, but I'm sure she heard that it's recorded. So, but thank you, David and Suzanne, for that. Yes, we are currently working with HUD, more specifically, Mr. Andrew Lee, myself and the two solicitors, and Miss Carla Clark, our division chief. And we are working towards that goal of having a HEARTH Act lease with that language in there. So we have not received anything yet. Right now, we are currently waiting on Mr. Lee and his team to get back to us. But yes, that is in the works. Suzanne, did you want to say something?
No,
Oh.
just that when we get that all done, we'll be happy to share it with you guys.
Yes. Okay.
Oh,
Thank you.
Iris has said
Iris?
put a comment.
Oh, okay. So Iris said she's having problems. She's not able to unmute. Oh dear. Let's see. Let me see if I can get you unmuted, Iris. Sorry about that. Our apologies. Let's see. Let me find her name. There we go. There we go. Okay, Iris, you should be able to speak and undo your mic. Oh, I think she left. Okay, she might jump back on. But while we are waiting for her to rejoin, we hope she can. Let me go ahead. I have pulled up the website, and the links are included in the chat, so they will be there. But this is the website for HEARTH. As you can see, it goes through the important bullet points that we discussed, a lot of those today in our presentation, but it is all listed here. And these little links right here, they are hyperlinks. They take you to these certain specific things. So if that is what you want to see, you can click on it and you can download those certain items if you'd like. If you scroll further down, there are these boxes that say HEARTH Act training for tribes, view approved HEARTH Act regulations and how to submit. So on this particular one, we're going to click on the view approved HEARTH Act regulations, and it takes us to all the approvals that we have done thus far. So they are in order with the most current year first, and within that current year, the most current one within that year. So as you can see, the last one approved was by Tunica Biloxi. There were a couple more that just recently finished up. We will be posting those on our website as well. But for the lenders on the call today, you can scroll through this list and you can see which tribes have the residential leasing code. And there are quite a few of them that do. So if you want, at your convenience, you can scroll through and look at all the tribes here listed. And you can click on any one of them and download their code. This is all public knowledge. So we're going to click on Saboba Band right here, just as an example, so we can show you guys. So as you can see, listed on the website is their approval page, their ordinance when it was approved, and the date. And then following it is their actual leasing ordinance. Within this code or ordinance, as we call it, is written the tribe's own words for their leasing for residential, and their own leasehold mortgaging information is in here. So that's what Suzanne meant by there's not a one cut and dry one for every tribe, because every tribe is different and their needs are specific to them alone. So these are examples of ones that have been approved, and the more current ones are also really good. So you can click at your leisure for these. I want to scroll down to the end right here. Let me go back to the HEARTH Act leasing page, and further down, if you scroll some more all the way down, you're going to see this additional information. So here's the presentation slides. This is approved HEARTH Act regs, another link to that page. Here is the administrative process flowchart. This process flowchart is essentially for the tribes, because the tribes are the ones that, they really want theirs done under that 120 or within the 120-day statutory time frame. So the flow chart was created so that the tribes can see what is happening at what point in the process. There's an informational series that is available to watch. There is a link to 25 USC 415, leases of restricted lands. There's also the 52 IAM 13 policy, which is the approval of tribal leasing regulations under the HEARTH Act. I'm going to go ahead and click on that. This policy is the policy that we go through with the tribes for every time that we have an overview session with the tribes. This policy is discussed and it's gone over so that the tribes are aware of what they need to do. But this policy is 19 pages long. I will not be going over this. You can view it at your convenience on the website. You can download it for yourself, but this is literally a step by step of everything that is done during a HEARTH Act review. Hit the back button. And last but not least, this is the legal sufficiency checklist for tribal leasing regulations. Like I said, we've got some tribal folks on the line today. So they will, at their leisure, download this checklist. And this is their guidance tool for when they are constructing their own leasing regulations. This is what Suzanne and David referred to earlier. But this is put on the website for the tribe's convenience and for them to use as a guidance tool.
Sharon, can I jump in real quick? To make a comment to just kind of clarify on the chat language about this section, the sample lease on section 184, on their section 184 page. Thank you, Iris, for that. I just want to really clarify that as lenders, you cannot, well, and I don't even know if it's as lenders, but the lease that you're lending under, that you're using, if it's a HEARTH Act lease, it cannot have secretarial authority language in that lease. It is a big problem. And what happens is tribes take a sample lease that has has the 162 secretarial authority language in it, and they have the tribe's chairman or the tribal official who's authorized to approve HEARTH Act leases approve this lease. And that is not a valid lease at that point. Most likely, I'm not going to say that across the board, but a tribal officer or a tribal chairman cannot approve a secretarial authority lease. And that is why we need to come up with this language for the HEARTH Act, so it doesn't have the secretarial authority language in the lease, that it refers to the tribe's HEARTH Act authority to approve the leases and the leasehold mortgages, at which point then the tribe's officer or chairman or whoever can approve that lease or that leasehold mortgage. And I hope that makes sense. That's the language we're working on. It's not available right now. So please don't use secretarial 162 authority in a HEARTH Act lending document. David, do you want to add anything to that? Did I miss anything or misspeak?
No. Again, just a point of clarification. Again, I think leases under 162 are governed by the regular 162 regulations. I think HEARTH Act leases are governed by the tribe's ordinance, things of that nature. But going back to the lending documents, I think what have occurred, I think basically those lending documents or HUD documents in particular, they basically reference that it's a secretarial approved lease, which is basically for HEARTH Act purposes. Is it correct? I think it was the point Suzanne is making. So again, I think there's those questions come up when you do have basically a HEARTH Act lease that it comes up and basically comes to your desk for approval of a leasehold mortgage. I think to look at the HUD documents and other related documents, whether it be VA or others. I think look for that language, and we have basically in the past. Particularly on, maybe a few years back, I think we worked around that, and I think we can find a workaround for you until we do have language that all parties can agree to. So.
Hi, this is Iris. I think I'm unmuted now.
Yeah, you are.
Yes, you are.
Okay. Suzanne and David, thank you so much for making that clarification. And I think we'll work on updating our webpage just to insert that language as well, so that there's no confusion between the two. And just glad to hear that you all are working with Andrew in our Office of Loan Guarantee on developing some updated language that will be useful for the HEARTH Act leases. So I really appreciate the conversation that's being had today and the clarifications that are being made, because that really helps support the homeownership process and alleviate any delays or barriers.
Thank you, Iris. Yeah, we really do want to make this work. We really want to come up with something and make this work, because it would be an awesome tool if we can do that. And it would, alleviate a lot of problems when it comes to leasehold mortgages and such. So we are working as diligently as we can to get this done. There is a question in the chat that says, will the lease you create be the required version, or can the tribe create their own compliant lease? I think that depends on HUD and the lending requirements that HUD has for their loans, or the VA has for their loans, or I think there's USDA loans as well. So I think that if the tribe creates their own, which they certainly can, they would have to get that lease approved by the specific agents, the lending agencies, the HUD and the VA and the USDA. If it's approved by them, I mean, I will let Iris speak to that question, whether you guys can use that or not, or whether that's a viable option. Iris, you want to, and no, BIA does not have to approve the form lease, I don't think. David, am I misspeaking
No,
here?
I think we have had, on a review of basically of tribal ordinances, HEARTH Act ordinances for leasing. We've had tribes, basically some drafts indicated that basically they will have a form lease. We've indicated, you look at, I think again, the tribe that they want to create a form lease, they can do so particularly for purposes of residential leases. It's much easier, I think, and expedites the whole process. So they do have a form lease. We basically, but so there is no HEARTH Act ordinance that we've approved that would prohibit a tribe from developing a form lease for purposes of residential leasing or residential lease or mortgages. But basically, we have encouraged tribes not to basically we have encouraged tribes to allow themselves the flexibility basically in the ordinances to allow them to develop form leases, as long as those form leases comply and are consistent with their HEARTH Act leasing ordinance, it's fine. I think, again, going back to what Suzanne indicated, we don't have to, I mean, once a HEARTH Act ordinance is approved, we don't look behind that. We don't look at the leases until they're recorded, and we only look at leases when they're HEARTH Act leases when they're recorded, to be sure that they have sufficient information in those for us to record them in our land's title system. So I hope that answers the question that was put on the chat. But again, I think, we, just to clarify again, we have not approved any form leases per se under a HEARTH Act ordinance, but that doesn't mean that a tribe cannot develop that form lease, particularly for residential leases.
But I do think that they would need to get that lease at least reviewed and approved by HUD or VA if there's a loan, if there's a HUD loan associated with it. Iris, is that correct or is that not correct?
Yeah, that's a question that I think is best posed to Andrew Lee, who oversees the policy in the Office of Loan Guarantee.
Correct.
So I will pose that question to him and then we can follow up with folks.
Yeah, I would agree, I think, in that regard, Suzanne. But again, I think, from our perspective, I think what we're looking at, as long as that form lease basically it follows and tracks their ordinance, it does not conflict with their ordinance, they can develop that. I think, again, and with the language, I think we would have to, I think, when HUD gets, I think things will flow a lot easier once we have model language that the tribes can adopt and place in their leases and so forth. But with that regard, I think it occurs to me we haven't seen, or at least I'm not aware of any basically form or model leases that have been developed by the tribes for that purpose. So,
and it looks like Ted has said in the chat that for USDA loans, the lending language has to be approved by USDA prior to execution of that lease.
No, that's correct. Yeah.
Yeah.
I mean, but again, that's not really, it's approval of the lending documents and not of the lease.
Right.
Okay.
Right. Right. And then there's a question, says there is confusion with surveys getting recorded, breaking a multi-acre property into smaller lots, but only the master lease is recorded. How does the HEARTH Act make sure that legal descriptions are formally broken down so that each lot or block within a larger piece of land has an independent legal description for purposes of financing. David, do you want to take that one?
In that regard, I think again, at least going back to the lease ordinances that basically we recommend for approval that are approved by the secretary. Basically, all those lease ordinances include language that a particular lease, basically a residential lease, business lease, or otherwise, basically contains sufficient information basically to allow for the recording of that particular lease and for us to track the title. So I haven't brought the question up in the chat yet, but essentially, yes, I think can be a master lease, basically, which I typically, in my experience, I typically see for business purposes. I've seen them for residential purposes, things of that nature. But to the point that they basically will record the master lease, but again, for plats, parcels that basically fall under that, we would still need a description for that particular area. I think so. I think we would still be recording. So I'm not aware, and maybe Carla or Sharon can speak to that. But I think under 162, we will record the master lease. But again, when leases are basically, with the plots or apartments or they're recorded under the same file, the master lease, but then basically is very specific as to what unit or what plot or what parcel is being rented once you break up the 5 acre, 10 acre, 20 acre parcel.
And also just to note before Sharon and Carla jump in, when we review Tribal Hearth Act regulations, the language on the recording says that the lease has to include a legal description that is sufficient for LTRO to record the leased premises. So that kind of narrows down, is it the entire, 5 acres, as David said? No, it has to be, if you're only leasing 1 acre out of that 5 acres, the legal description in that lease has to be for that 1 acre, so that LTRO can identify which portion of that 5 acres is being leased out. And I hope that answers the question.
Yeah, the residential context is very similar to what you would have on a business master lease, say for a purpose. The master lease, say, is for a mall area. Within that mall area, you have basically space leases. So that space lease basically would have information that would include basically the legal description of the master lease. You could track it to the master lease, but it would also include whatever footage, or area within that master lease that is being occupied, i.e. the premises that would be occupied pursuant to that particular lease. So.
Yep. Thank you, David and Suzanne. Great questions. I appreciate that. Wonderful conversation. Also, just as a jumping into the comment, as a realty specialist that came from the field, we did all kinds of work like this, where we would work with the tribe as they were developing their, let's say, subdivision. And then later on, those subdivided lots would be, mortgaged out or sublet it to the individual who wanted to build a home. So it is important that the legal descriptions match. And like David said, at the very beginning of these projects, that the legal description is done by a land surveyor or a qualified individual who is doing that surveying of the land, and only encumbering that 0.45 acres, of the 5 acre lot. So when title is pulled, we are only requesting title on that 0.45 acre where the house is sitting. So, and there is language built in each of these codes that are listed here, language pertinent to that tribe. So all these codes listed here have the ones that are marked with residential that have their leasing code, they have that language built in there regarding that the legal description must be sufficient for LTRO to record it. So how it's changing from the time that it's recorded to when it's getting to the lender that's a good question. We don't know. We just know that you, the lender, should be working with the tribe if this is a HEARTH Act tribe to ensure that that legal description is in fact the correct one. The same also would apply to 162 leases. You would be working with the agency to make sure that that legal description is the correct one. There's another question that just came up. Is there a BIA contact list for when we need help or have specific questions? Can a tribe legally sublease a HEARTH Act lease to themselves for the purposes of breaking down into smaller lots, asking for residential? And then the question further says, but I guess it could apply to other types when the tribe is going to be the borrower on a mortgage. David, Suzanne?
Well, the tribe is the lessor. So the tribe, a HEARTH Act lease can only apply to tribally to 100% owned tribally trust land. So the tribe is the lessor. So David?
No, I think I mean, basically, look, the tribe could lease, I think, perhaps, again, look, they're sovereign governments, so I think basically it really depends on what their authority under the Constitution, bylaws they can do, and everything else. But just a general example, I think if you have a tribe A that basically has what we call Section 17 corporations, basically that for all intents and purposes they have the authority of the tribe to act. It could be a housing authority, for instance. So as Suzanne indicated, the tribes are the lessor because they hold the beneficial title to the land. They can lease, i.e., to themselves, but they're actually leasing to a separate legal entity, which would be a 17 corporation or a business authority or a transit authority, whatever is that's created pursuant and authorized pursuant to the Constitution or bylaws. So again, I think the tribe could then, I think, say they leasing to the housing authority, which the housing authority then takes control of basically of doing leasing and approving the leasing for residential leasings. The tribe could then basically turn around and probably, they could be the lender, or the tribal authority could be, the borrower, or the tribal authority, or the housing authority could be the borrower. So, again, it's just really not. I mean, you would have to look at it from a case-to-case basis, in my view. I don't know if that answers your question. Who was that? Dana? Okay.
Yes, she says thank you. So, and thank you everyone for those questions. Great questions. Going back to the website, I'm going to click on upper right here. It says Division of Real Estate Services in the corner here. These are all just quick ways to show you where to go. Scrolling down, if you have to scroll all the way down, there under more resources right here, it's Real Estate Services Training. Click on that one. And when you do, this is going to pull up. HEARTH Act Training for Tribes is just that. It is the overview session more in depth, and we cover the policy for the tribes. The most current ones are listed here. So if some of our tribal partners here that are on today they can certainly go and take a look at these ones. We just conducted our last one for the fiscal year, which was August 14th. So the tribes will again have an opportunity to attend another live session as soon as we look at the calendar and we begin planning for 2025. But further down, if you scroll down further past the tribal information, is the training for the lenders. This is the training that was done last year, January of 2023. It is still relevant. It was for the lending systems focus group. It was a very large group. We had some great questions there. If you are interested, please, by all means, click on that training and listen to it. And you can also hear the questions that were brought up in that training session. On this same page is where this training from today will go for all of you who signed up to attend. You will receive a notification that this is in fact been loaded to the page, and you can then watch it at your convenience. So I just wanted to show you that so that you know that the training for today will be listed on the public website for HEARTH Act training for lenders. There is one more question in the chat. It says that brings up the question, how would that work for a LIHTC project for a rent to own project?
Well, quite frankly, I'm not quite sure. That kind of stumps me what the actual question is. I think I suggest this comes from Philip. I think Suzanne put into in terms of contact information, my email, Suzanne's email. I'd like to get some clarification on what is actually being asked here. Again, I think, I'm not quite, I understand what you're saying for a rent to own project. I don't know how that changes the underlying lending, basically in that regard. So we can have a discussion about that if you'd like to follow up, but I hesitate to delve into that or give you an answer, which I'm not quite sure I understand what's being asked. So, Suzanne?
No, I'm not quite sure either. So yeah, I think a separate conversation would be very helpful, and we could hopefully answer the question. Thank you.
Thank you for the question, Philip. We appreciate that. There was a part 2 to Philip's question that says, where a TDHE has leased land from the tribe, and then after 15 years, the homes can be sold to the renters. So that 2-part question right there, Philip, if you would like the information to contact the solicitors are in the chat, so you can contact them and continue that conversation after the presentation today. Okay, that's it for the website, showing you the different buttons and whatnot that you can do. You can also click on Division of Real Estate Services to see all the other items and information listed there for the other things that we cover, like broadband, fee to trust, rights of ways, mortgages in Indian country, leasing on individual Indian and trust lands. So all of that information is here, and it will take you to those specific pages. Okay, we have another question in the chat from Deborah. It says conventional lenders, FNMA, etc., GSEs will also review residential leases. So the form of the lease will need to address their MOUs, etc. And I think we already did. We covered that one earlier. Oops. My apologies. I read that one out, but it was actually done earlier. And yes, there will be discussion for that. Alrighty. That's all we have for you today, folks. Like I said, the information for the training that was done today is located on the website under the real estate services page. Scroll down, go down to the one that says HEARTH Act training for lenders, and you can print out the actual slides that were used. These were the slides that were used last year. We only did a very tiny modification. So We will post the one from today, the one that we did. We will post it here alongside this one, and the video for today's session will be listed here. Thank you so much to everyone who attended, and we thank you for everyone for the questions. They were great. As far as we're concerned, that's all we have for you today. Have a great day, and thank you all.
Thank you, everybody.
Thank
Have a
you,
good day.
everybody. Bye-bye.